a shareholder is alive, the person can very well do it for himself, herself. But if sometimes family members find old physical share certificates lying at home or maybe any other document, then what happens? Because then that person is not alive. Then how to do KYC? Then in the first process itself, you are stuck.
Yeah, so if in case of demise of a shareholder, it becomes a transmission process.
Right.
So as per section 56 of the Companies Act, transmission means passing off legal title from deceased to their legal heirs.
Right.
So transmission is a complex exercise because one needs to prove that you are the genuine legal heir and you are the only legal heirs. And it varies from religion to religion as well, and of course
succession laws will come into
succession laws will come into play. So some people are governed by the Indian Succession Act, and some people are governed, for example,
Hindu
by Muslim
succession.
law or by Hindu Succession Act. And there are people who are resident of foreign country, or they became citizens of another country. So they will be governed by their respective succession laws wherever they were living. So it becomes a complex exercise for the legal heirs to justify they are the legal heirs. So
So in this entire process, the very first step is to reach out to company and get your information of share, and then you get your KYC done. But these people can't do it, then what exactly do they do?
These people cannot do their KYC because the shares belong to their ancestors. So they have to deposit a death certificate of their parents or their grandparents to explain to the company that this person has passed away. We need to...
So maybe we can take an example that a grandfather and now a grandson or granddaughter is trying to get these shares in name of maybe parents or their own name. Then
if their parents are alive, then the parents have to do the process.
The process will have to be in the parents' name.
Because they are the class 1 legal heirs. As per, if we talk about Hindus, Sikhs, Jains, Buddhists, they are governed by Indian Succession Act. So class 1 legal heirs, the parents will be entitled to claim those investments. However, if there are multiple siblings, the parents are brother, sisters, and they have to first decide who wants to do the process, or everyone wants to do the process. In some states, all of them have to come together. In certain other states of India, one or the other legal heir can initiate the process.
Having NOC, no objection certificate from others?
That will be in the court. That NOC or renouncing affidavit or consent affidavit has to be filed in the court once they initiate the succession certificate process or the will probate process, or if they have other assets, then letter of administration.
So death certificate, and along with that succession certificate be required.
It was compulsorily required. Succession certificate is compulsorily required. It was compulsorily required, but currently, last year, SEBI gave certain relaxations that even a legal heir certificate obtained from a revenue authority higher than a tehsildar, I mean, you can use that legal heir certificate which mentions all the legal heirs. So they can approach the company without a court order. And if one person out of that wants to claim it, then others will give their no objection in the prescribed format of SEBI. That we have no interest in claiming these. Please allow the other legal heir to claim back these investments. So that is an alternative. But many companies are still insisting on a succession certificate.
So can we show them SEBI rule, and that's how
legal heirs investors have been trying to do that. Some companies oblige, but some companies still, as an aspect of due diligence, insist on a court order. So that is another challenge which every investor has to face company by company.
So once maybe people have gotten hold of all these certificates given to company, then
the company will again issue an entitlement that you are the correct and rightful legal heir. We are satisfied with the legal documents you have submitted, and then that legal heir has to do the process of claiming back the shares from IEPF authority.
Then you go to MCA website, create your
login credentials,
IEPF Form 5, entitlement letter, and then again more documents. I believe that MCA website will show all those documents.
Once the claim is filed, you have to download those documents, take a printout, self-attest those documents. There is an indemnity bond which has to be submitted with 2 witnesses along with requisite value stamp paper. So indemnity bond is a crucial document. All the 3 concerned, that is the 2 witnesses and the shareholder or the legal heir, has to sign with date and with their correct address.
Okay.
And that indemnity bond along with IPF Form 5 and KYC documents have to be submitted to the nodal officer of the concerned company.
Okay, this
Yes.
indemnity bond only happens in death cases.
No, it happens in all the cases of claiming
Okay.
from IEPF authority.
Okay, indemnity bond having 2 witnesses, this applies even for
Everyone, every
alive
claimant has
investors.
to provide an indemnity bond that
Okay.
I will receive this much amount of dividends and these many number of shares from you, and I will indemnify you in case of any.
Okay, okay, this
Yeah.
is important process, and then IPFA will approve it, and then those shares will get
come to the
transferred in the
demat.
name of the legal
The legal
heir.
heir come to the demat account of the legal heir.
But eventually it has to go to one legal heir, or if multiple ones are involved, then what
Yes,
happens?
if the court order or the understanding says that many legal heirs are claiming their respective share, then all of them will have to separately do their division process with the company, their transmission process with the company, and the company will issue respective entitlement letter to all the legal heirs, all the children of the deceased.
Okay, so based on amount or number of shares? How?
It is division of shares.
Division of shares.
Yes.
So if 5 people are there, 100 shares, so that's how.
Yeah, 20 shares will go to each of them.
to-
Yeah.
Okay, got it.
Yeah, so they will have to file 5 claims with the IPF authority.
Okay, so it sounds very traumatic. That how will a family?
Legal heirs, for legal heirs, it is very difficult. They have to either come on board and give power to one person to claim it, or they will all have to do this cumbersome exercise and wait for the approval from IPF authority, which will happen as per their filing dates and were their documents correct.
Correct.
Yeah.
Okay, thank you so much for sharing this information.
Sure. I will just explain one more point, that for legal heirs who are settled abroad or who were born and brought up abroad, they have to see the interplay of foreign law as well as Indian law.
Okay.
So they have to either be if their parents left a will or created a trust abroad. For example, many investors are in the US. So their legal heirs will have to first see how the division happened there, and they will have to then approach Indian courts for authentication of a foreign probate or a foreign LOA. Or in case the parents passed away intestate, they will have to then approach Indian courts for a succession or a letter of administration to prove their rights.
Then whose law will prevail?
So in that scenario, if the parents did not demarcate or did not devolve their properties to the children, they have to follow the Indian law to obtain an Indian court order sitting abroad. So it becomes
again a very
another difficult
process.
exercise for foreign investors.
Right,
Yeah.
correct.